Hello, everybody. Today's June 23, 2024, and I'm honored to be here with our guest, Bharani Padmanabhan, and he is going to give us an update on his last talk with us from a few days ago about judicial bias, potentially, in Massachusetts. Bharani, tell us what's been going on with your case.
So after I spoke with you, I went ahead and filed what's called a blue brief or an appellant brief with the Massachusetts Supreme Judicial Court, which is the topmost court in the state. So I filed it 9:45 Wednesday night, and it was docketed on Thursday. It was an emergency petition coming straight from the single justice court, or as they call it here, county court, the SJC court for Suffolk County, where Justice Gaziano tossed it, sight unseen, no explanation, no memorandum, even though state law requires one. So it was an emergency petition for an emergency injunction in the single justice court, and it was appealed as an emergency petition for an emergency injunction to the full court, and it just sat there. The court misclassified it as miscellaneous and not as a certiorari petition under Chapter 249, Section 4, which is mind-boggling to me, and then did absolutely nothing about it. All of Thursday, all of Friday. So I kept sending emails to the clerk, to the official email address for the court, and nothing happened. So on Friday morning, I hopped into my car, went to Staples, got 4 copies of the brief stapled, and then drove over to the courthouse, hoping to actually meet them in person Friday morning and say, okay, what gives? This is an emergency, a real emergency. You need to act before June 24th, which is what I went to court on June 11th to do. But I couldn't get to the courthouse because of the Celtics parade. The police had completely cordoned off all the roads around the Supreme Court. And so I came back, mailed it, and then sent them an email. And of course, nothing happened. And then at 4:05 p.m. on Friday, June 20th, June 21st, the clerk called me, and she did so after I emailed her at her individual email address and not the clerk's office official email address, saying, "Oh, well, yeah, it doesn't look like the court's going to be able to get your case before the 24th." So I explained to her that it had been an emergency right along. It says so right on the cover. And it was an emergency petition in the single justice court, and then it got transferred as an emergency appeal to the full court. It wasn't something that slowly bubbled up from below, like a normal course of appeal sort of stuff. And she just heard me silently and said, well, as it doesn't look like it's going to happen, so file a motion to expedite. That's about it. So anyway, I filed a motion to expedite, and then I sent an email to all the justices on the Massachusetts Supreme Court, informing them of what just happened, and that clearly I had done everything that I needed to do by the rules to get justice before June 24th, and yet nothing had happened in their court. So that's where it stands for the moment. Here we are Sunday morning. This trial that I contend is intended to railroad me is due to start at 9 a.m. tomorrow, Monday, the 24th. And I still haven't heard back from the Supreme Court. As a physician, of course, I asked the clerk if anybody in the justice system is on call over the weekend. She didn't appreciate the joke. So
That's interesting.
anyway.
So let me just ask you as a devil's advocate, can't anybody just paste the words emergency on a case? I mean, does you're saying it's emergency mean it's an emergency?
Well, to start with, if a plaintiff says it's an emergency, you have to give it some consideration, some due respect. In the single justice court, it was treated as an emergency. I got an answer from the single justice within a week of filing the case, and that's pretty quick by court standards. So the single justice court did treat it as an emergency petition. They denied it within a week. And so when I appealed that to the full court, it automatically meant that it was going there as an emergency petition that it had always been and was treated as such in the single justice court. So it didn't change character after the single justice denied it. It was the exact same emergency relief petition that it had always been. So I can't think of any legitimate reason why it would be treated any differently in the full court.
Okay, so for people who hadn't seen, I'm going to link the last previous video from a couple days ago. For people who haven't seen that, what makes your what's the body of your emergency? What makes it an emergency in your view?
So there's a trial starting tomorrow morning at 9 a.m. in Norfolk Superior. It's a defamation case. I brought the case. I'm the victim of defamation, and I'm the plaintiff. But the defendant, a former, now retired state employee, is being defended in this private slander suit in violation of state law by the Attorney General of Massachusetts. You have the entire AG's office, 3 lawyers, 1 paralegal, and so on, defending this person in a civil case, which is unprecedented. I have not come across a single other example going back to 1790 when the office was established. So that's unusual, and the involvement of the Attorney General in this private civil case has skewed it irreparably. All the judges have bent over backwards for the Attorney General. They've been giving them a lot of deference, which they wouldn't have given to a private lawyer if she had come with a private lawyer, as she's required to by law. And therefore, there's a significant amount of railroading, a significant amount of bias, just in the way the judges have dealt with motions in limine and so on. And then on top of that, I found forensic evidence that the Attorney General spliced out this lady's testimony, Loretta Cooke's testimony in Lawrence District Court, which private lawyers would not have had the ability or the authority to do unless, of course, they bribe somebody heavily. But I've never heard of that either. So the fact that the Attorney General is involved has put a huge thumb on the scale in favor of the defendant, yeah. And so there was more than judicial bias or a perception of bias. I mean, the standard is even a perception of bias is wrong and we need to mitigate it. Here I have presented forensic evidence of bias where the court colluded with the Attorney General to splice out testimony that the Attorney General found embarrassing in some way, and then treated me very differently compared to the general public. And you would think that forensic evidence, sworn forensic evidence of strong bias, or as the US Supreme Court put it, impermissible hostility, which is what I've been facing, would be enough to garner some interest and some action on an emergency petition by the Massachusetts Supreme Court. That clearly has not happened. And so Friday evening, while all of that was going on with the clerk, I actually sent an email to all the judges on the Supreme Court bench and a copy to everybody involved in the Attorney General's office and Justice Heidi Brieger, who's the Chief Justice of the Supreme Court, the Superior Court, who is also a party in my petition. So everybody's been notified. Everybody's on the same page that this is what's been happening, and I put it on record, and they all know.
So what I found interesting about your case is kind of the circling of the wagons. Can we use the defendant's name here?
Yes, Loretta Cooke. It's a public case.
So she's a nurse, and she was an investigator for the medical board, and she was involved in your case by the medical board against you, correct?
Yes.
Okay, that was some time ago, and you were suspended. And we're not going to have time to get into all of that, but that's an interesting case in and of itself, and people can read about that. You've posted it. You actually have a reasonable explanation in, I think, the Valley Patriot, and we can give a link to that separately. What she did was go up to the judge during your trial, or whatever you want to call it, your hearing, and kind of announce some solidarity. We are both officers for public safety, as if it's really the judge and she against you, and she's
That's
an arm of the state, and the state has to be protected. So insofar as you might have made a mistake here, you brought this to the attention of one of the attorney generals, and how odd that was, that she was trying to kind of circle the wagons and create a united front against you, the plaintiff, the state against you. You're the outcast here.
Well, I was being deposed.
Well, fair enough. And so the attorney general understood that, or assistant attorney general understood that you had taken umbrage to that particular phrasing, and lo and behold, that particular phrasing is the only thing missing from the
Yes,
entire record. Correct?
that one sentence has been spliced out.
Now, I asked you before whether the judge could be deposed in the deposition sense, not in the getting rid of him sense, about any kind of memory of this. Is that a secondary avenue for possibility? And would the judge have remembered this? I mean, again, you mentioned there are so many cases, hard to say.
After you asked me that question, which had never occurred to me, I emailed the judge, but I have not heard back from him.
So where do we stand on this? And I'm going to try to get off scene here and see if I can put up your Patreon QR code.
The question of deposing a judge as a witness is very interesting. I haven't had the time to this week to look up the case law on that. He would be as a witness. I suppose it's entirely possible. The forum is the question. I don't know if he would be a witness in my defamation case, or it would be before a committee of the Massachusetts legislature, which is where it really should be, or in a hearing ordered by the Supreme Judicial Court, which I very much doubt they're going to do. The issue of bias, however, is very strong, and it is imperative that the Massachusetts Supreme Court and the trial court, because I have brought this petition to the attention of Judge Mark Halal, who is supposed to take over this case tomorrow. He's been suddenly brought into this case, and he is only in Norfolk Superior until June 28th, and has made it clear that this case should be wrapped up before June 28th. So there's some sort of a rush to get this case done, squared away, tied up with a bow before June 28th. And looking at the way the SJC is dragging its feet, I guess that's what's going to inevitably come to pass.
All righty then. I was going to see if I could get the QR code so people can support you, but I can show the window at the very least in the meanwhile. Let me see if I can pull it up here. Anyway, that might be a little bit of a technical challenge for me without having prepped
That's
for it.
fine.
So,
you can do that later, I suppose.
yeah. Let's see if I can find it anyway. Oh well. So give us a summary for people why they should be upset about this, why they should care about you per se, as far as this goes.
So if this can happen to me, this can happen to you, this can happen to your loved ones next. So what happened to me? The government arranged for a lady to go lie to the police that I was harassing her, and sent a suspicious package to her home, that I had a gun, all things that were intentionally inflammatory and designed to make the police react. The police, however, were very professional, and they didn't react, which is why I'm still alive and walking. According to the police, my life mattered, and I'm very grateful. And then the government got together with the court to splice out a sentence in an official court recording, which is a humongous no-no. The court is required to be neutral. Neutral means neutral. And in this case, the government and the courts were one. It was seamless. I can't tell to this day where the judiciary ends and the executive branch begins. And that's not the way this republic is supposed to work. We are supposed to have three separate branches of government. Here, the executive and the judiciary have glommed together. And so I do not have any neutrality in the court. If this is allowed to stand, this could happen to you. You may find yourself one day in a court that is not neutral. And that's not how it's supposed to be here in the United States. And that's why it's important, because it has what they call an injury to the public interest. And that's public means you.
All right, lovely. Well, I did manage to find the QR code, and I think that will get people there. When I asked them not to be confused, it's a Patreon page for you. You have something about Martha Coakley up there. You might need to update the listing. Now, what
Hmm.
was it? What was the reason you had Martha Coakley's name up there? And since we're kind of tossing names of ex Massachusetts Attorney Generals, what's the relationship of Maura Healey to your case?
The reason
Our current governor, former Massachusetts AG.
Right. The reason why the Martha Coakley stuff is up there on the Patreon is because we did a program together about steward healthcare. And my point had been in a published article, in a published column in the Valley Patriot newspaper, a very good newspaper, I might add, is that without Martha Coakley, there would have been no steward healthcare because it was she who stood up in court and swore under oath that selling Caritas Christi, a nonprofit charitable organization, to a private equity company to set up a for-profit hospital system for the very first time called Steward Healthcare was the reason Steward Healthcare exists, the reason all the Massachusetts hospitals got looted. So no Coakley, no Steward, no looting. So that's why that Patreon page was set up. So Maura Healey, who is our governor presently, was the attorney general at the time when the decision to splice the court audio was taken. And her assistant at the time, Elizabeth Dewar, is now on the bench at the Massachusetts Supreme Judicial Court. And her partner slash spouse at the time is now also a justice on the Massachusetts Supreme Judicial Court, Justice Holohojian. So it all reminds me very strongly of Huey Long. And I actually put that in a column too. So yes, it's incredibly hard for me to even contemplate getting any level of justice, given that everybody involved in what was done to me is occupying such high seats of power in this Commonwealth.
Okay, so here's your article about Martha Coakley. I'd like people to also find the article about you. If you remember the name of that article where you talk about your um, winding story.
There are quite a few of them. One would be that, it's nice to be Martha Coakley's buddy. That's also on the Valley Patriot webpage. If you just put Padmanabhan in the Valley Patriot webpage and search for that, you'll see a whole bunch of my columns. I wrote about 90 columns in all, but not all of them are on the website yet. So yes, that case was about Loretta Cooke specifically, and the fact that Maura Healey was coming in to defend her at public expense, even though state law prohibits her from doing that. It's an illegal act to spend money on this case, public money, our money, tax money. And so, yes, that column was actually pretty self-explanatory. You should be able to find it on the Valley Patriot website.
All righty. So it's a little bit loud on my end, so I'm in a hotel right now. So this is kind of our own emergency broadcast.
Thank you for
Um,
that.
and I'm going to let us both get back to our Sunday lives. And thank you so much, Bharani.
I thank you, Dr. Bhatt.